Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you're going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Erin.
Good morning, David. How was the drive-in this morning?
It was very nice.
Very nice?
We have good weather right now, so.
We do. We're very fortunate in California.
Mm-hmm.
Okay, so for the past few weeks, we've been discussing trust and trust disputes,
Mm-hmm.
and this week we're going over different scenarios.
Mm-hmm.
So for today's scenario, let's say I recently found out that my mother created a trust with my stepfather a month before she passed away. I do not think she knew what she was doing because she had Alzheimer's. What can I do now?
Okay. Well, this is a blended family, and not everything is as nice as it is depicted in the Brady Bunch.
No.
So a lot of times blended families don't get along, and when the natural parent dies, the children of that natural parent have reason to believe that the step-parent will not give them a fair shake of the estate. And trusts work in different ways, too. Sometimes trusts are very carefully drafted to be respectful of this blended family so that the children of the first deceased spouse don't have to wait until the second deceased spouse passes away in order to receive their gifts. Other trusts are drafted in a way where you have this trust with two spouses, one passes away, then this trust splits into multiple trusts in which a portion of the trust estate at the time of the first death goes into a still revocable trust where the surviving spouse can basically do whatever they want. And the other remaining portion goes into this other trust, which is an irrevocable trust, and it is administered with certain restrictions to maintain the surviving spouse's life needs without giving them a total right to deplete those assets. So first things first is to figure out what type of trust this is. So when you have a two-person trust and one person passes away, that person's portion of their intent may become irrevocable, and therefore the heirs of that first deceased spouse may be entitled to terms of that trust. So first things first is to demand a copy, preferably through an attorney, because the attorney knows how to put in all of the law, for a copy of the trust. And if that surviving spouse shows their true colors, and in this case, they may encounter some resistance, in which that beneficiary should then go ahead and file a petition to compel the trust, analyze the trust with an attorney to see what their entitlements are as they sit there on that day and in the future, because it might be that they get cashed out and it's done, and it might be the case that they have to wait till this person passes away, Mr. Brady, and wait till he passes, and then they're going to fight over what's left. That being said, it's not just a matter of figuring out what you're entitled to by the language of the trust. You have to also make sure that the assets are managed in a specific way too. So the trust may provide some sort of mechanism to divide the trust so that the proper portions are being funded into each trust. Let's just say the first spouse who passes away brought a lot of property into the marriage, and that property really should go to the kids. It's not property that comes out of the marriage, and therefore the entitlement of the surviving spouse is minimal of this vast wealth. I've seen this before plenty of times. And so what the kids want to do is they want to get accountings, and they want to keep a careful eye, maybe even put the remaining trust under court supervision in which accountings are submitted, because what they don't want to do is just sit back and let the surviving spouse sort of pick and choose what assets go where, or decide that all of the assets, including all the separate property, goes into his or her revocable remaining trust, and then that surviving spouse will say, okay, well, I'm going to exercise my right to change my half of the trust so that only my kids get all the property. And by the way, I'm going to put all of the property in that specific trust. And therefore, when that person passes away and the kids of the first deceased spouse do nothing, they may realize that they are beneficiaries of a trust that has no assets. So you want to be proactive and you want to keep a careful eye. Otherwise, this stuff can be manipulated. I mean, you know, most family trustees are not sophisticated. They don't appreciate, I mean, to the level where they'll appreciate so much their duties of impartiality that they will stay their hand and not act in their self-interest and do things in a very egalitarian manner. Most people are sort of, you know, regular folks who aren't professional trustees. They act based on their own set of values and their own self-interest. So if someone has this situation where they're the surviving spouse, well, it's in their self-interest to put all the assets where they want to put them. And they have their own set of values, and they don't value their relationship with the predeceased spouse's children that much. Well, then ultimately that's going to result in a bad result for the first spouse to die's children.
Okay. Thank you very much.
You're welcome.
Okay. And if you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.